Let's turn to the elements of a valid contract. Now we know that in order for a valid contract to exist, there must be mutual assent, meaning the two parties must agree to the contract. Now in the law, when we measure mutual assent, we look at two factors, and those two factors are offer plus acceptance, meaning in order for there to be a valid contract, there has to be an offer and there must be acceptance of that offer. Now obviously there's a lot of issues involved with this. Now how do we know what is a valid offer? Well, under the CISG, a valid offer is an offer that indicates a definite intention to be bound, an intention to be bound by the offer. Under Article 14 of the CISG, a communication between two parties is an offer when it's a proposal for concluding a contract, and the proposal is substantially definite and indicates the intention of the offeror to be bound. The offeror is the person making the offer. The offeree is the person to whom the offer is made. Now the offer can be made either by the buyer or by the seller, so that's why we don't refer to them as buyer and seller. Instead, we refer to them as offeror and offeree. Now how do we know sufficiently definite? So, because one of our two aspects is not only an intention to be bound, but also sufficiently definite. Well, it's sufficiently definite if it indicates or describes the goods to be sold, if it specifies the quantity, and that can be either expressly specifying the quantity or implicitly specifying the quantity, and price. There must be an indication of the price for the goods. Now again, that price could be specific. It could be $80 a barrel, or it could be implicit. We could say the price of barrel, the market price of oil as of March 15. So the three things we need are a description of the goods, a quantity, and the price. Goods, quantity, price. And again, quantity and price can be express or it can be implicit in the language being used. And remember too that a court interpreting a contract under the CISG is permitted to look at a wide range of factors: testimony, evidence, conduct of the parties, any of that. Now, another issue that comes up with offer is how do we know it's an offer if in fact it's an open offer? How do we take the role of an advertisement, for instance? When you look in the paper or you look on the web and there is a price next to a good and it's being advertised, is that an offer to sell you the good? Well, you may think yes, that it appears to be an offer, but under the CISG, the courts have taken the position that an advertisement is not an offer. Instead, an advertisement is an invitation to make an offer. So when you go on the web and you're buying a good that's located in France, for instance, and you see the price of the good, description of the good on the web, that's not an offer. That's an invitation for you to make an offer. So when you click buy and you said, I would like to buy one of that item for a certain price, that's the offer. So the advertisement is just an invitation to an offer. It's not an offer itself. Now, we talked about price, and we said price can be either express or implicit. Now, what happens when the price is left open in a contract? If the price is not specifically related, it can still be a valid price if we substitute a reasonable price under the circumstances. If there's a reasonable price under those circumstances, we can fill in the open price term. Firm offers is another area that comes up. The question of how long do we have to hold an offer open? Now the general rule, and you'll remember this from your introductory legal studies course, is that an offer can be withdrawn at any time. One always has the option to withdraw an offer before it's accepted. Now once it's accepted, it's too late. The contract comes into existence. But until acceptance takes place, ordinarily an offeror can withdraw his offer. Now what if the offeror, say it's a business, say it's selling, I don't know, mobile home, and it says, I am offering to sell you this mobile home for $30,000. And I will hold this offer open until next Saturday. Say someone comes into the business that day and says, I would like to buy that mobile home. I'll pay you $35,000. Well, the law says the person who made that original offer, even though he said he would hold it open, is not bound to hold it open, because an offer can be withdrawn at any time before acceptance. That's the common law. Now, under the CISG, a party can be bound by a firm offer even if it's not in writing. Even if it's not in writing. Furthermore, if a offeree acts in a way that indicates reliance on the offer, then the offeror can be bound by the offer and not be permitted to revoke the offer. An offeror can be bound by the offer if the offeree has relied on the offer. For instance, if it's involving a commercial sale of goods, and the party offers to sell goods in a certain amount, and the offeree then goes and rents a warehouse to hold the goods and makes additional orders for remaining parts to go along with the goods, then even though the offeree has not accepted the offer, the offeror may not be able to revoke that offer. Now let's talk a little bit about forms, and one of the forms that's used to make an offer is called a Proforma invoice. Now ordinarily an invoice is a bill. It's sent to say, look, this is what you owe us. But in the international context, what often happens is that the seller will prepare what's called a pro forma invoice. And this pro forma invoice will purport to show what an actual invoice would look like if the contract went through. So the pro forma invoice is going to be a formal document addressed to the buyer, and it's going to lay out the terms and conditions of the sale, as well as describing the goods, identifying the quantity and the price of the goods. Now this pro forma invoice is a offer. So a pro forma invoice is not an invoice in the normal sense of the word. It's not a bill. But what courts have done is construe that pro forma invoice as an offer. Now we'll talk about some more forms that are used later, but just wanted you to give some background on that pro forma invoice now. And in fact, I've got an example of a pro forma invoice up on D2L for you to look at.